to promote the study of the law of the sea. Just one thing that I forgot to mention. If you see below in the page, there is an interpretation icon, is a globe icon. So you can click on that. There is a possibility to switch to Arabic for those of you who would like to follow the discussion in Arabic. Before introducing our speakers and starting this session on maritime boundary delimitations and Lebanon, just allow me to thank all the colleagues, international partners and friends who made this double event possible. I will spend a few words also on the first session that we already implemented earlier this month. But I would like to thank in particular, yes, our partners from ARDD and our Law for Palestine colleagues who co-organize and are hosting this event for the fantastic job done, and the consortium also for the study of maritime affairs and the blue economy, CONSMAR, on behalf of which ASCOMARE is participating also here today. And in particular, the National Center for the Sea and Maritime Law of the Ankara University, DEHUKAM. We have we have the pleasure of having with us Hademun now, and Centro interdipartimentale di Ricerca sull'Adriatico e il Mediterraneo, CiRAM, and the International Center for Ocean Governance of the Western Sydney University. Just as I was mentioning before, a quick recap, let's say, of session one. As most of you know, the first session, so this is a two-day session. The first one was implemented on December 8th, and centered on Palestine and the law of the sea. We focused in particular on three aspects. The first one involved the maritime boundaries situation of Palestine in respect of neighboring countries. So we discussed, for instance, the situation of Palestine and Egypt, Israel, Cyprus, and touched also upon a little bit about the situation with Turkey. Then we moved to discussions on the membership and prospective role also on Palestine in several international bodies. In particular, we discussed, for instance, IMO and International Seabed Authority. And then we exchanged on recent developments in the region, trying to focus on the possible way forward. Something very important that was indeed discussed last time, and I think that made also the event very entertaining in a way, is the possibility of considering not much only the challenges that the different countries of the Eastern Mediterranean Sea. We know it's a difficult area for a number of reasons, you know, like geographical, political, legal. Of course, we will discuss a little bit later on the position of course of Lebanon, but we have also it's a region where there are 4 non-contracting parties to the UN Convention on the Law of the Sea. There are certain interactions also from the legislative standpoint, and it's important therefore to look forward and try to identify also the possible range of the means and solution that could better address the issues at stake. Now, just to some takeaways from the last discussion, from the discussion that we had earlier in December. I think it was generally agreed that there is big potential in any case in addressing the maritime boundary issues of Palestine and other related issues concerning the law of the sea in international fora and institutions. There is also growing attention on the topic of maritime boundary delimitation in the Eastern Mediterranean region. We will discuss some of them, some recent developments, for instance, especially when it comes to the October agreement between Lebanon and Israel. Therefore, further space and resources should be devoted also to technical discussions on the subject. And I think this makes these events also very important opportunities to further an exchange on the related issues. And also another aspect we discussed last time is how the ongoing situations between two countries, like the problems that Palestine that exist when it comes to maritime boundary delimitation between Palestine and Israel, could have implications in respect of the discussions and the technical and political discussion that the states have with other neighboring countries, like when it comes, for instance, discussions or parallel discussions ongoing with Egypt, right? So this is something very important to bear in mind, I think, in the framework of the discussion, that indeed the problems, not only the ocean's problems, as UNCLOS says in the preamble, right, are closely interlinked, but also the different positions of the countries bordering this sub-region. Now, when it comes to the introductions of the event of today, I will not repeat what already said by Raquel during the previous sessions. You can look at the descriptions on the Law for Palestine website. But let me just remind everybody here, indeed, that the objective of this initiative is twofold. The first one is to exchange on the maritime boundary delimitation and Lebanon, with an eye, as I mentioned, to the recent agreement. And the other one is to identify also, as I say, the possible means to address some of the pending maritime boundary issues, also for other rim states. So to use it to look, for instance, at state practices and other aspects that could be relevant for the overall discussion. Very, very quickly, the discussion will be developed in two parts. The first one involves two presentations from our speakers and experts. I will introduce them in a second. And the second one involves a Q&A session that will give the possibility also to participants and to other to our colleagues to ask questions. I will explain more in detail the process when we reach the Q&A session, but just for you to know, indeed, that we believe this is an important part of the event, the possibility to engage indeed in this exchange on the technical issues. So, without further ado, allow me to introduce the two speakers of this session. We have with us Dr. Laury Haytayan. Laury is an oil and gas policy and geopolitics expert. She's the Middle East and North Africa Director at the Natural Resource Governance Institute, an independent international non-profit organization that provides policy advice, research, and works on advocating for better management of resources and energy transition in oil-rich countries. She played a leading role in establishing the MENA Oil and Gas Knowledge Hub in Lebanon in 2014. She's the host of the Energy Espresso podcast, a solution-oriented podcast. You can find it on YouTube and listen to it on Akawati. Last but not least, Laury teaches geopolitics of oil and gas in the East Mediterranean at the American University of Beirut. We also have with us Professor Aref Fakhry. Aref is associate professor at the World Maritime University. He joined the university in 2014 after over 15 years of experience as a lecturer in important international institutions, including the IMO International Maritime Law Institute in Malta, the International Ocean Institute, and the Catholic University of Lebanon. He also worked as a consultant on maritime issues for a number of important EU and the UN bodies, including the European Commission, UNEP, IMO, and UNCTAD. Aref is also advocate registered at the Montreal Bar in Canada and is member of the Canadian Maritime Law Association. So thank you very much, Laury and Aref, for being here with us today. I will now give the floor to you, starting with the Laury to present on your topic. You can directly share the screen. I don't know if you have a presentation that you want to share with us. Just one thing to remind you that the time limit for each presentation will be 15 minutes. And if I could ask you, please not to speak too fast also for our interpreters. Thank you very much. Laury, the floor is yours.
Thank you, first of all, for inviting me. It's a pleasure to be with you. I wish I was a doctor. I didn't have the stamina and the discipline to continue to be a doctor. And today I'm speaking on my personal capacity, and and whatever I say doesn't represent NRGI's view, my organization view. Already we're off, and this is on my own capacity. We have 2 weeks off, so I would like as well to wish everyone happy holidays and a successful 2023. So just like briefly, as you said, like I really like to hear from the attendees and hear from them their views, or if they have questions. So I'll be very brief in what I'll put on the table regarding the Israel and Lebanon maritime deal that was signed in October 2020. So Lebanon and Israel, as you know, they are two countries that don't recognize each other, so they're at, you can say they're at state of war, and therefore that's one, and they don't have any direct negotiations or direct representations. That's one. Second, since 2010 and 2011, we had this maritime border dispute between both countries, based on different interpretations of the two countries regarding their EEZ and the methodologies to use in the delimitation. From 2010 till 2022, they were, or 2020, when the last round of negotiations started, there were different attempts from the Americans, from the US, to mediate. And this dispute was never directly tackled by both countries. It was always by a mediator. And as I said, because Lebanon and Israel don't have any direct relations, so therefore it was the best way to move forward, to decide to go on to use a mediator. And the only mediator for both countries that has the leverage and entrusted were the Americans. So in 2012, there was the first attempt by Ambassador Frederick Hoff to reach a solution, but it never reached a solution. And then after that, there were, at that time, Mr. Amos Hochstein was in charge of the portfolio on behalf of the Obama administration. He tried to solve the maritime border, was not successful. And after that, there was a short-lived attempt by David Satterfield, Ambassador Satterfield, that failed, until we reached 2020, October 2020, when Lebanon declared openly that they were going into a new round of indirect negotiations with the mediation of the US administration. At that time, the Trump administration. The mediator was Ambassador John DeRoche. And then a year later, the mediator changed, and Amos Hochstein, the special envoy of President Biden, took over, and we reached to a successful resolution of the decade-long maritime dispute in 2022. in October 2022. So exactly after 2 years of indirect negotiations and mediation, we reached a solution in October 2022. So, so this is, if you want, a bit of a history of that dispute. To go to a bit of the details, the technical details. Basically, Lebanon in 2020, so directly to tackle the last round and not to go back to the details of the old rounds that were not successful. So to get some lessons learned from why this time it succeeded. So basically in 2020, the negotiations started. The US administration and the Israeli government were under the assumption that the dispute was supposed to be around, or the negotiations were supposed to be around 860 square kilometers. That was the area that was disputed since 2011. So that was the assumption. The negotiating team from the Lebanese side entered to the negotiations with a different position. And the position was that they claimed 1,430 square kilometers on top of the 860 square kilometers. And that was for them pure technical claim, because they thought that the negotiating team, the new negotiating team that was that involved 2 military and 2 civilians, and 2 of the civilians were one a geology specialist. He was part of the Lebanese Petroleum Administration, so the regulator who is dealing with the oil and gas sector in Lebanon. The other civilian was a maritime expert, maritime law expert. And from the military side, you had one who was a technical expert, if you want, and he was working in the hydrographic office of the army, Lebanese army. So basically, all these people had prepared their strategy based on the methodology that they thought was the best place for Lebanon and in favor of Lebanon. Basically, on the 3 levels and the 3 approaches of the maritime delimitation, which was the equidistant line, followed by looking at any special circumstances that existed, and equitable solution, which was like after you do the delimitation, you look if there are any disproportionate effects of that delimitation and you rectify. So based on this level approach, the Lebanese negotiating team had a different starting point for the delimitation from the Israelis. The Lebanese government was saying that my delimitation starts from Ras al Naura, which is the recognized border of 1923 between Lebanon and Palestine by the mandatory forces that existed, the British and the French. So, and then they said, and based on the equidistant line and based on special circumstances, there is this island called Tekhelet on the Israeli side, very close to the shore, that Lebanon considered it to have a disproportionate impact on the whole overall delimitation. And therefore, Lebanon decided that that Tekhelet rock or island shouldn't be given any effect into the delimitation. And therefore, this is how they came to draw their line and enter into the negotiations. So from the beginning, the Israelis and the Americans were against that approach. They considered that the negotiations were based on the very well-known 860 square kilometers that were defined according to the coordinates sent by Lebanon and at the same time by the Israelis to the UN. And these new coordinates or this new delimitation and interpretation was never recognized even by the Lebanese government, who never sent it to the UN to claim it. So this was the position of the US and the Israelis. So for a whole year, we had a deadlock. Negotiations were not moving because the Lebanese position was like sticking to that position of maximal claim, and the Israelis and the US were refusing it. So to unlock it, and here I finish the story. So to unlock these negotiations, there were like the Lebanese government moved away from the legal claims and maritime delimitation and move on to something that they call it as a practical approach, which was, let's focus on the natural resources and let's see if we can get somewhere based on our natural resource gains that we want to make, instead of being fixated on the delimitation based on the legal frameworks and based on a legal, what the UNCLOS says. So automatically they shifted into looking at, in the area, what could be of interest for Lebanon regarding natural resources, and they started negotiating over the natural resources. And this is where the fixation became about this potential prospect that Lebanon called it Kana, and the whole focus on the delimitation and the negotiations became on that resource, on the prospect of gas in that area. And this is how they came to a solution where, if you read the 4 pages of the agreement, it is like one part of it, it's detailed about how to manage that prospect if found between Israel and Lebanon. And the final point that I want to say, that there was an important role for the companies to play. So if we wanted like the lessons learned for others, so it was like companies had a role to play, especially Total, because there was a lot of responsibilities on Total. So there were discussions with Total if Total would agree on what was proposed, especially on the special, if you want, special status of this potential prospect if found about like resource sharing, but in a creative way, because Lebanon and Israel don't recognize each other, and Lebanon didn't want to share anything with the Israelis, and they didn't want to look as if they were sharing the resources with the Israelis. So the mediator had to be very creative in how it came to write the deal. But at the end of the day, if you look at the deal, it could look as, in case Kana was found, it looks like just another unitization agreement between companies and between a government. But overall, the perception was that Lebanon is not sharing the resources with the Israelis. On the contrary, they have the upper hand. But if you go into the details, and then we can discuss into the financial details, that was the parameters were agreed in the 27 October agreement between Israel and Lebanon, and later on 15 November between Israel and Total, the French company that has this license to invest in that block 9. You see that there is a financial agreement that Israel has to agree with Total for Lebanon to be able to really benefit from that resource if that prospect is found. So I'll stop here, and if there are any questions later, I will be more than happy to answer.
Thank you very much, Laury, for this very, very interesting insight also, and I'm sure that there will be some interest in knowing more later in the question and answer session. And now I will give the floor to Aref for his presentation.
Thank you, Pierandrea and Laury, for the first presentation. I think it really sets a nice background to my part. So what I'll do is I'll try to share my screen now, and basically I want to say hello to everyone already, and I'm providing this presentation on legal observations regarding the agreement establishing a maritime boundary between Lebanon and Israel. And as far as the outline is concerned of this talk, let me just say that I will try to direct my talk on providing legal observations purely from an international law perspective, first and foremost. I should point out that there have been some legal or difficulties, practical difficulties in accessing the actual official text of the so-called agreement. That is to say that it's not easily accessible from, I don't know if the screen is working, my share screen is working.
Not yet, Aref.
Okay.
We see that there is a loading script though.
I see. Okay, let me start that again then perhaps. Is it, yeah, is it working now?
We see a slide with introduction.
Okay, right, I seem to have a problem with it. Yeah, perhaps I'll just stick to this format. Sorry for the technical difficulties. Are you able to see my slides now?
Yes,
okay.
Very well.
All right, so what I was going to say also is that one of the difficulties of talking about the recent agreement from the legal point of view is that it is not easy to access the official text of the agreement from the usual sources that lawyers usually obtain these documents from, ministries of foreign affairs or the Secretary General of the UN, because the treaties, according to the Charter of the United Nations, have to be deposited as an official copy. An official copy of the treaties have to be deposited with the Secretary General. Of course, I, like others, have been able to put my hands on this document, but it's purely informal, so to speak. The last thing I want to obviously signal is that I'm, even though I work for the World Maritime University, the views expressed in this presentation are my own. They do not bind or represent in any case my employer or any state or entity involved in this dispute or situation for that matter. So I think that in terms of the core of my presentation, I will try to tackle this first by elaborating a bit more, following on from Laury's presentation on the context, the legal context to the agreement, that is the applicable international law of the sea, just outlining instruments that may have governed actually the background to the negotiation of this agreement, talking about the United Nations Convention on the Law of the Sea, UNCLOS, talking a bit about other treaty law that may have been applicable, as well as the notionary customary law. The next part will tackle some observations on the agreement itself. So things like, what is the agreement about? Is it a treaty in international law? Who are the parties to the treaty? Is it in force? Is it published? Well, I've already sort of talked about that. So very legalistic, if you want, aspects of this agreement. I will thereafter move on to talk about some core or non-commercial, if you wish, non-commercial aspects. Perhaps I will leave that to the other speaker, which are as important as the commercial considerations, namely maritime security in the Eastern Med, as well as marine environmental protection. Just before concluding, I'll touch on implications in terms of international law for other states. So if we were to start off by talking about the legal context to the agreement signed between, or concluded between Lebanon and Israel with US facilitation, we probably are looking at a table of agreements that looks like the one you have on your screen. To start with, we have the United Nations Convention on the Law of the Sea of 1982, UNCLOS. The interesting thing about UNCLOS is that Lebanon, Palestine, Cyprus, and a few, or most, as Pierandrea said, most of Mediterranean countries are parties to UNCLOS, but Israel is not a party to it. So one can wonder about the applicability in the background to the negotiation of the agreement between Lebanon and Israel of this particular major treaty of law of the sea. One can, of course, point out that even though Israel is not a party to UNCLOS, a lot of the provisions of UNCLOS are deemed to codify customary international law, which is applicable to non-party states anyway. I think you heard Laury also speak about some earlier treaties that may have been adopted or concluded by the colonial mandatory powers, that is Great Britain and France, of the territories under consideration in the Levant, the so-called Newcomb Agreement of 1923, which actually is a historic instrument that did influence the negotiations, as you heard also from Laury. There's also the Israel-Lebanon Armistice Agreement of 1949, which came up with also certain provisions. Most of these agreements dealt with boundaries on land, not so much at sea, which is the subject of the agreement that we are talking about in this session. And I think one should point out some other important treaties or that apply in the context of the negotiations, namely the Barcelona Convention for the Protection of the Marine Environment and the Coastal Region of the Mediterranean, which was concluded in the in the 70s and then updated in 1995, to which both Lebanon and Israel are actually parties. So that is a fundamental instrument that I will come back to when discussing the implications for marine environmental protection later on. There is also to note the Vienna Convention on the Law of Treaties of 1969, which really sets out the general law applicable to treaties. And I'm going to draw on that convention a lot in this presentation in trying to depict or describe what we have on the table now as an agreement between those two states. Interestingly, neither Lebanon nor Israel are actually state parties to the Vienna Convention on the Law of Treaties, but it is understood that that convention, like UNCLOS, represents a lot of customary international law that is applicable in any case. And the Charter of the United Nations is, of course, always to be taken into consideration as background. So moving on from this contextual legal framework, I wish to now talk in a pointed manner about the agreement. First of all, my first question was, is there an agreement? This is a bit bizarre question to ask, but you will recall that it's difficult to find the agreement on official websites of ministries of foreign affairs, on the UN treaty collection. So it is not so bizarre in that sense. The other consideration is that we're dealing with a tense region of the world. So anything can actually happen in those circumstances. What we know is that on or around the 11th of October 2022, that is just just over 2 months ago, the media widely reported on the Lebanon government as well as the Israeli government having reached an historic agreement delineating their maritime boundary. A press statement by the US Secretary of State Antony Blinken dated the 27th of October 2022 congratulated the governments on reaching that deal. But again, it is difficult to put our hands on that on the official version of that treaty or agreement. So perhaps we can conclude that there is an agreement, but we are yet to understand the gist and contours of that agreement. The title of the agreement, it's interesting that in any convention or treaty or agreement, you will normally find, from a legal point of view, I say that, a title to it. So the United Nations Convention on the Law of the Sea is the actual title to UNCLOS. So is there a title for this agreement? There is no title given to the agreement in inverted commas. It simply refers to itself as the agreement, which is a bit odd again. However, there is an expression used once in the correspondence which the US government actually sent to the Lebanese and Israeli governments in relation to that agreement, and I put that down. It reads, agreement related to the establishment of a permanent maritime boundary. So we can assume that that is the actual title, or the official title of the agreement. The next point is a fundamental question for lawyers, but also more generally, is this agreement a treaty in international law? We know that treaties are fundamental in relation to international law. We know that according to the Vienna Convention on the Law of Treaties, an agreement can be contained in a set of documents and does not have to bear the usual state signatures on it. And that is taken from Article 2.1a that you have on the screen. So one could argue that this agreement, which isn't really a traditional document that the governments of the parties have actually affixed their signatures to, is actually a treaty, even though it is to be found in a set of documents, which is the case, including letters exchanged with the US government by Israel and Lebanon. The other matter is, who are the parties to the agreement in this case? The agreement refers to parties in inverted commas, but does not explicitly define them. We note that in the US letter to both governments, there is a definition of parties as a term used in the agreement, and that is the Republic of Lebanon and the State of Israel. And I put the quotation for that. So we may argue, or we may conclude that Lebanon and Israel are parties to this agreement. The US is not for itself a party to the agreement. It may have just been a mediator or a facilitator, and there is no private party like Total that would be a party to the agreement, even though the operator of the prospect is mentioned in the agreement. The next point is consent to be bound. Perhaps I'm going to be a bit brief on that because of the shortness of time, where it says that how did the parties actually express their consent to be bound? And even though they did not actually sign the agreement, because it's again based on correspondence initiated by the US government, well, that's fine in terms of international law, because the Vienna Convention on the Law of Treaties tells us that an exchange of instruments can actually provide the mechanism for the expression of consent to be bound. And I placed on this slide now the format of the letters that the US government exhorted each of the parties to actually send to the US government, to express their agreement with the terms and conditions. The question of whether this agreement is in force is to be answered, as you can see in the affirmative from the last bullet of the slide. And that's again based on the correspondence between the parties, which is actually quite in compliance with the rules expressed in the Vienna Convention on the Law of Treaties. So we can say that this agreement is now in force from the date that the two parties sent to the US government their intention or their expression of agreement with its terms and conditions. I'm not sure I have time still to dwell on some other legal niceties of the agreement. I think so in the
if you want, Aref, we can. It's fine. If you need other extra 5 minutes, it's okay.
That's great. Thank you very much for that, Pierandrea. I'm sorry. Okay, so I just want to bring up here. There's been an issue whether this agreement will needs to have to be formally approved internally in each of the two states. The question is actually touched on very neatly by the Vienna Convention on the Law of Treaties that says that a party may not invoke the provisions of international law as justification for its failure to perform a treaty. This rule is without, okay, so that's good to know. We have, just as an example, I didn't show you the equivalent in the constitutional law of the other side, but in terms of the Lebanese constitution, it is kind of clear, if you look at the very last provision that I'm highlighting now, treaties involving the finances of the states and general treaties that cannot be renounced every year shall not be considered ratified until they have been approved by the Chamber of Deputies. And that has not yet been done. So one could question, in fact, whether that will be a hurdle at some point, at least in in the domestic context of these two states. The next point is whether because there have been a lot of detractors to this agreement on both sides and from other actually contexts. And one would wonder whether there's a way to challenge the validity of this agreement. Again, the Vienna Convention on the Law of Treaties tells us that there are interesting heads of invalidation for agreements, being fraud, corruption of a representative of a state, coercion exercised over a representative of a state, coercion of a state by the threat or use of force, and treaties conflicting with peremptory norms of general international law or jus cogens. One could argue here that maybe the principle of self-determination of the Palestinian people is one such rules of the peremptory norms of international law. So having talked about the agreement in itself, I'd like to just sketch some pathways for maritime security and marine environmental protection in the aftermath of this agreement. In terms of the maritime security, I think it is clear that the agreement has the potential to stabilize, in part, the tense relations between the states involved and the non-state actors acting on their territories. Interestingly, Lebanon and Israel are both parties to the IMO-sponsored Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, SUA, of 1988, which came in the aftermath of the Achille Lauro hijacking in 1985, as well as the Protocol for the Suppression of Unlawful Acts Against the Safety of Fixed Platforms located on the continental shelf of the same year, 1988. But neither state has actually acceded to the 2005 protocols that amend these instruments. This is very important. It talks about maritime terrorism and the legal mechanisms for bringing to justice the perpetrators. So the next point, I think, in terms of marine environmental protection, one should not lose sight of the fact that we have a convention, a Barcelona Convention, operating in the Mediterranean Sea. And to the convention, there is a protocol that is the Offshore Protocol that talks about, in fact, the prevention and response to incidents of pollution from offshore oil and gas developments. Interestingly, Lebanon and Israel are both parties to the Barcelona Convention, but as far as the protocol, the Offshore Protocol of 1994 is concerned, only Israel is a party to it. And I think it's important to highlight the need to ensure that there is proper regard for the marine environment. The last segment of my presentation, ladies and gentlemen, and sorry for being so lengthy, just to talk about the implications for other states in terms of the law. I think one can go back to the basic principle of the Vienna Convention on the Law of Treaties that says that a treaty does not create either obligations or rights for a third state without its consent. So this is a very fundamental rule in international law. I think one could also add that the agreement does not affect the right of the Palestinian people to self-determination, as it is enshrined in the Charter of the United Nations. The agreement has not been formally opposed by other states. Some states in the region have applauded the conclusion of the agreement. So just to conclude with a few points, I would say that this agreement, in inverted commas, has served as a good application of international dispute settlement mechanisms. It may have actually brought some surprising results in a context of sanctions, faltering statehood, and the Russia-Ukraine armed conflict. But I think to end on a positive note, we can argue that it is a peaceful resolution to a dispute, however, with lingering pending issues. Thank you very much for your patience with me and your attention.
Thanks to you, Aref, for this very, very interesting presentation, which touches upon a number of collateral aspects connected with the agreement. And in a way, it was also interesting to see, for instance, how Laury discussed mentioned the switching process from the legal argument to the natural resources element, and at the same time we see with Aref how there was a change also in the format of negotiations and in the framework, the legal framework indeed that was used also to reach this agreement. Thank you very much to both of you. Then I think if we can move to the next part of this session, which is the Q&A. Just to remind everyone here just some general rules. Okay, it will be possible for you to raise your hands or to write down your questions into the chat part, and if you want to ask a question, and it would be great to see you, so if you can turn on your camera and ask the question directly. Otherwise, yes, I have with me also some colleagues from ASCOMARE, Giacomo Grappoli will be here also if there is anything, Giacomo, that you see maybe in the chat and some contributions. Let us know, so maybe we can run through them also one by one. And yes, I can open now the floor for questions. I don't know if anyone has already some question. Otherwise, I can start with mine. I have plenty of questions. No, it was very, very interesting. Going back, there has been a lot of discussions after this agreement. I think it was a breakthrough for someone, unexpected breakthrough, because of course this is connected, as we know, with the other issues. So which involves the maritime boundary in general. So as we know, for instance, the agreement starts after the so-called buoy line. So there is a part in any case that has not been delimited because it's connected with the different interpretation on the specific point of the land boundary terminus, which I believe it would be, of course, something probably we will see what would be the implications in any case of this agreement also for that negotiation. What it's interesting is to see how, as Laury was mentioning, the impact that in any case, on the one hand, private actors and entities could have in this kind of negotiation processes. And on the other hand, also the importance of the economic trigger. So this is something that, of course, for in this specific case was very relevant. And to connect, therefore, the points of the two presentations and what Aref mentioned at the end concerning the marine environmental implications, for instance, of the security implication. My question to you is, do you think that a similar process, so which involves, of course, third-party interventions, which could be mediation or conciliation, is or could be applicable in other situations, which in other disputes, maritime boundary dispute pending in the Eastern Mediterranean region? We know, of course, this has been discussed already, the respect, for instance, of the situation between Cyprus and Turkey, or the situation between Palestine and Israel. These are, the conditions are different, of course, so it's this is something that should be taken into consideration. But if in this case we had the economic trigger, you know, and in other circumstances it could be, I don't know, something else. It could be a security trigger, it could be an environmental trigger. Do you think that the same kind of approach could be applied also elsewhere? I don't know if some of you...
Anyone can answer it?
No, to Laury or Aref.
Yes. Okay, so let me just quickly some feedback and then answer your questions. Definitely what Aref is saying about, like, where is this document? Where is this official document? Definitely it was very interesting because of the Israeli elections. It was leaked first in the Israeli media. And that was for the first time that the Israeli media leaks these issues or these delicate issues instead of the Lebanese media leaking it. Because in Lebanon, we're very well known that all politicians, to destroy a deal, or if they disagree, they just leak it and they make it public affairs, and then it becomes so distracted so that you cannot, so it blocks it. So this was the first time that the document, the 27 October document, was leaked from the Israeli media. And then there were no disapproval, or there was no opposition from the Lebanese saying that this is not the right document. And so I guess whatever document we had was the document to base it on. And then later on, the Lebanese and the Israelis had to send it to the UN representatives. And then later in November, I think the UN representative here in Beirut took the document to the UN and deposited it at the UN. So I didn't check, but most probably now we might see it on the UN websites, where they put all these maritime deals, etc. But again, that was very important about, like, yes, where this agreement is, if it's an agreement or letters, by the way. It was called letters, exchange of letters. And that was, again, one way to not take this agreement to the parliament. Because I agree with Aref, Article 52 of the Constitution was very clear. This agreement should have passed by the parliament. But if it passed by the parliament, it would have been the first time that the Lebanese parliament approves or disapproves an agreement that involves Israel. So in that document, you would have recognized Israel as a state because you have signed a deal with it. So they wanted to bypass these things. So they started saying that these are letters exchanged between the Lebanese and the Americans and the Israelis, etc. So they made it as if there are two different things, and this is not an agreement. So that said as well. So, and I think on your point, Pierandrea, on the incentives, basically the Lebanese incentives were purely economic, related to the resources and the ability of the Lebanese government to really use the resources, exploit them, because the current Lebanese government, or the one like before, they thought that exploiting the resources could save Lebanon and the economy of the country. So they saw that way. Not everybody agrees on that in the country, but that was their main incentive at one point. They didn't care where the line is, where maritime law is, what that law says, etc. They saw that if this will unlock potentials for the resources and for gas, let's do it, and let's be very practical. Israeli side, the military component and the security component was very important. When they started the negotiations, for them, this was seen from the security angle. So that they wanted to do a deal with Lebanon that will kind of end a decade-long dispute that could have at any moment led to a war or to a conflict between Lebanon and Israel. So that was for them that incentive. And then even when you said that the way the limitation started away from the terminus, as we say, the way from the starting point, it's because the Israelis had security concerns. And the only way that Yair Lapid could sell that agreement in Israel was by saying that the military endorses this agreement. Therefore, it is in the benefit of the Israeli public. And that's why we are going with it, because it came at a time where there were elections and Netanyahu was fighting Yair Lapid, saying that you were like you couldn't hold on to the pressure of Hezbollah, etc., etc. So incentives are very important to understand as well for the success of this deal. And the last point that you mentioned, I think, and from conversations we're having in the region, Eastern Mediterranean, the perception is like maybe there's a lesson for Cyprus in what we've done with the Israelis. Cyprus meaning between the Greek Cypriots and the Turkish Cypriots. And this idea of resource sharing, this idea of companies having a role in unlocking potentials, etc. That is something that it resonates in some policy places inside Cyprus, being it on the Turkish side or the Greek side. Going beyond, I think they're still stuck, the Turks and the Greek, for instance, they still stuck on their rigid reading of what the maritime law says and the UNCLOS and the role of the islands and all of that we all know. So it's more about sovereignty issue than like really using it like economic incentives to drive this solution-oriented path.
Thank you very much, Laury. Aref, do you want to add something? Or?
Yes, sure. I'll just be brief and add to that. Perhaps also some impressions that what we had in this case of the agreement between Lebanon and Israel is a cocktail that maybe it's alcoholic, maybe it's non-alcoholic, I don't know, but it's a very unique cocktail. You have in Lebanon itself a state which is undergoing a lot of challenges, both from within and from the outside. You also have the non-state actor, a non-state actor with quite an influential impact on the dossier itself. So I'm not sure that that will be present in other circumstances and other contexts. I guess that maybe one of the states involved in this case may be seen somehow as having bowed to difficult, really, pressure in terms of this agreement, because I think that something I kind of omitted in my talk earlier was that the agreement, when it comes to perhaps the issue of the exploitation or the exploration of this prospects, doesn't really sound very balanced between the two states. There is a kind of an imbalance on one side over the other. So that perhaps could also signal to neighboring states that maybe this is a state that could perhaps negotiate treaties in a similar fashion with them. So that's not so. I mean, that is not such a good thing, really, to say. But when observing it from the outside, I think one cannot fail but see some challenges on the side of one of the states involved. So without elaborating further, I'll just stick to that. Thank you.
Thank you very much, Aref. I see that we have a hand raised. Paula.
Well, I think I have to elaborate further. It seems to me, and maybe I'm wrong, two things. One is that in the immediacy, the only one that will be exploiting the gas is Israeli, because their field is already set up to start, or has already started in the previous 2 weeks. And Lebanon has a long road too. So that is already something tricky. I mean, I imagine they couldn't do any better, but that is already tricky. And it links what my fundamental question is. If it's not a treaty, even only because it's not yet accepted by the Lebanese government, it's not been voted, and it is not equally been voted from the Knesset, which may not have the same law, but in a way, somebody has to, each state has to state that they want the agreement that they enacted. It's like a floating balloon. Now, the condition, if there is not a treaty, whoever can recede whenever they want, there is no penalty, there is no guarantee, there is no time frame whereby it has to be like that, otherwise you incur some sanctions or whatever. Am I correct? It's very, okay, maybe a step forward, but it's a very, how would I say, it's a balloon in the water. It can go with the current here and there, change, get submerged, with nobody being able to do anything about. Correct?
If you allow me to answer on the very pertinent questions you're raising, or your views on that. So basically, as I said, when Lebanon shifted its position from really sticking to the legal text and UNCLOS to being more practical and looking at the potentials of resources and how to exploit. So they wanted to make sure that there are guarantees that the exploitation will start. So just like a brief history, Lebanon launched its first licensing round in 2013. It closed it in 2018, 5 years later, because of political deadlocks that it had encountered, which are very similar to today. Caretaker government, a lack of ability or inability to elect a president, and the dysfunctional decision-making, which took them 5 years to close the first licensing round. So, and then Lebanon signed a deal on 2 blocks with Total, the French company, Eni, the Italian company, and Novatek, the Russian company, a consortium of 3 companies on 2 blocks, Block 4 in the northern part of Lebanon and Block 9 in the southern part of Lebanon. So the dispute was around Block 9, where Total and Eni and Novatek had stakes. So basically what happened, it's like Lebanon, when they switched to resource negotiation and not maritime delimitation negotiations, they wanted to make sure that Total gives guarantees that they will relaunch their activities. Since 2020, Total had done 1 drilling in Block 4, which was an empty well, and then they were supposed to start working in Block 9, which they didn't do for different reasons. COVID, the collapse in Lebanon, lack of appetite from the companies, etc. So they wanted to make sure what happened in the deal that they made. They got the guarantees from the French and from Total to relaunch the activities. So in that respect, what happened is like the Israelis wanted to guarantee their rights as well. So they said, if this potential gas starts in the Lebanese exclusive economic zone, but goes across to the Israeli EEZ, Israel wants compensations. And who is going to pay for Israel? It's the company, Total. So that's why after the 27 October agreement, there was another agreement on the 15th of November between Total and Israel, that is a framework agreement that said step by step what are the Israeli rights in case there are common reservoirs, so that Total was allowed to announce that it is starting its activities in Block 9. So today we have an agreement between Total and Israel, exactly, and then we have a timeline for Lebanon when to start the drilling, which is end of 2023. If there is gas in that Kana prospect, and if that gas crosses to the Israeli side, Total and Israel need to come into a financial agreement, and Israel needs to be paid before Lebanon is allowed to start the exploration. So that's the agreement that Lebanon signed with Israel.
Sorry, but because of reciprocity, I mean, if there is connection between the two areas, the connection goes both ways normally. Instead, in this case, it would go, I understand correctly, if there is connection of what they explore on the so-called Lebanese side, physical connection with the field of Israel, Israel gets a revenue on what is in the Lebanese side.
Yes.
The Lebanese doesn't get a revenue from what is in the Israeli.
Because the deal says that Lebanon has the upper hand in starting the exploration, and therefore, if there is gas that crosses to the Israeli side, the compensation happens from Total, but the whole field is for Lebanon after Israel gets compensation. So Israel wants its right, so it's saying that you pay me first if there is gas, and then you do whatever you want. But I must get paid first to allow Lebanon to continue with the exploration.
Which means also, if I can say another nasty,
okay, last question.
The last nasty thing, that the main preoccupation of Israel, as usual, is not only security, but is exploitation, in a way, trying to extend its range of potential exploitation, because the deal is...
Israel is already producing gas. Israel has Tamar. No, Israel has Tamar, Leviathan, and today Karish had started in October right away when it was announced that there is a deal between Lebanon and Israel. The second day, Israel announced that Karish started production. So part of it was part of the deal as well.
And there is a pipe coming to Europe.
Maybe, we don't know about the pipeline.
So they say.
But what Paula said also raised an interesting questions, I think. So after the agreement, in any case, there were many commentators which in a way argued, for instance, that the agreement was, that there was a winner and a loser, let's say, in this agreement, right? That there was a party that benefited, that in any case got more advantages from this agreement than the others. So my question, for instance, is what do you think? There is really a winner and a loser in this agreement, or not? In any case, it's a win-to-win situation for both of them, for security reasons, for exploitation in particular reasons. What do you think?
Sorry, Pierandrea.
Yes.
In connection with your question, there is a question from the audience asking, is the boundary Lebanon accepted what it would get according to UNCLOS? So they are connected. So I think they can be answered together.
Sure, I could take that perhaps, and then maybe Laury will elaborate. I believe that the question that we got in the chat is a difficult one, but just to be honest, really, the UN Convention on the Law of the Sea does not specify the exact manner by which delimitation will occur. It comes out with broad principles and general rules, and it leaves a lot of maneuvering for states to agree mutually, if they can do that, on the delimitation of joint boundaries. However, we have a case law that has been developed by international courts and tribunals that give us indications of fair and equitable rules of maritime delimitation. And it is difficult to answer a question like that because one would have to take sides in terms of the data that has been put forward and kind of project interpretations of the different rulings and cases on the basis of the geographic and other actually attributions of the states involved. So it's not an easy one to answer. And there are people who believe that Lebanon got less than what international law gave it. And I'm sure that there are people also on the other side of this debate that believe that so I think that in terms of the question of the broader question that we are talking about that was initiated by Paula, whether this is a treaty or not, I try to perhaps myself clearly state my opinion that it does seem to be a treaty in international law. So that's my respectful submission to you. But it does seem to me also that it could be a floating balloon, as Paula said. There is a very interesting and kind of unconventional mix of provisions in this agreement. It is not just a maritime boundary delimitation agreement. It also talks about the exploitation of the potential prospects. Nothing is so clear in this agreement, and it does so by roping in a notional commercial entity or a private operator that is not even identified. And that to lawyers is a really a very bizarre type of agreement that only I think in extreme situations any reasonable lawyers or diplomats would actually agree to. So that you can maybe get the gist of what I'm trying to say there. Thank you.
Thank you very much to both of you. I see that there is a question from Ademun. Please, Ademun.
Yeah. As far as my understanding of international treaties are concerned, according to the Geneva Convention on the Law of Treaties, a treaty is an instrument between at least two state entities. In this case, it would be Lebanon and Israel. Secondly, that treaty would have to be ratified by the two parliaments, depending on how they operate. One country may be doing it through a decree or goes through parliament. I don't see anything in this treaty which suggests that it is actually being approved now as a treaty. Okay, that's my first concern, or at least my misconception here. The other one is I'm not very well acquainted by the sort of the details of this treaty, because I think from both Laura and Aref, it seems to me to be more of a treaty than
Ademun, we cannot hear you well. There is
yeah, there's something wrong with my computer, but can you hear some of what I'm saying?
Now let's try again, because maybe we can hear you better now.
Okay. Did you hear what I said before?
What you said before about the treaty or non-treaty comments, yes, we got that.
Now, the other one is about, there's a difference between a boundary limitation treaty through an agreement. A joint agreement.
No, we cannot hear you, Adamun. Would it be possible maybe to write it down, if possible?
Yeah, I think it will be difficult because I don't think I'm that technologically.
But now let's try again, because now it's yes, apparently the senior is back.
Now, the question I'm asking is was this a maritime boundary limitation treaty, a joint development treaty?
So sorry, Adamun, if I understood correctly, you asked if this maritime boundary delimitation treaty is a joint development treaty.
Well, is it a maritime delimitation treaty?
Or a joint development treaty. Okay.
It seems to me that two things are mixed in this treaty. Two state entities, and then a private entity comes in. How does a private entity come into the treaty between two state entities?
We can't hear.
No, we cannot hear you, Adamun. We got in any case the first question.
Okay. Can someone deal with that?
Yeah, just to say quickly that again, to understand the position of Lebanon, this was like Lebanon didn't want to go into an agreement that in any way can be read as normalization with Israel or recognition of Israel. So definitely they were stuck in a position where they couldn't follow through their position on the maximalist claim and impose it as the starting point for the negotiations. So, and then they moved into resource sharing or resource negotiations, but they wanted to make it in a way that doesn't look as a joint development agreement or any kind of resource sharing between both countries. So that's why the agreement came in that form where it came, about a lot of discussion about potential prospect, what happens in that case, and the company that is in charge of that block, how it should behave, etc., etc. But there is no. They wanted to make sure that there is nothing that is called any kind of collaboration, partnership, sharing resources, joint development with the Israelis, because that would have been unacceptable in the political context of Lebanon. So now, and we go into the details, we'll see what will happen if the prospect exists, if this gas exists, if they need to develop it, how this will develop, we see it. But they wanted to make sure that there is no any language that could show that there is kind of normalization or recognition of Israel. That was very important for the Lebanese negotiators, being it in the beginning, where the technical negotiating team, or later when the negotiation happened through political entities, and it wasn't technical anymore, it was more of a political negotiation with a touch of technicalities, with sprinkle of technicalities. And this is why, like, you see comments from like Aref commenting about, like, there is a lot of language that is not like the normal language or the normal provisions that you could see in a treaty or an agreement between countries. Even there is a lot of in the like future looking as well, and like other companies that would want to enter into any deals with Lebanon, they need to abide by this treaty, especially on the blocks 8 and 10, which are on the borders with Israel. The companies need to be acceptable by the Americans, or at least accept that the Americans are the mediator and are the arbitrator. And if there is, you cannot go to arbitration or any kind of form. You have to go back to the Americans and agree with the Americans. So definitely there is a lot of language that you might not find, and that is again something that companies who would want to be interested in the sector in Lebanon would look at it. And I'm not even sure if this applies to the Israeli side as well, So on the blocks, on the Israeli blocks, it applies on our blocks. I'm not sure if this is the same. It applies on the Israeli blocks where Lebanon has a say on who the companies would be coming and investing in blocks that are close to Block 8 for Lebanon, for instance, because Israel has a say about who could come into the consortium or not, and the US has a say. They don't have to be. Companies shouldn't be sanctioned. So companies should be there are like certain criteria. I'm not sure. I need to go back to the document again to see if that applies to the Israelis, because today the Israelis have launched their licensing round, and some of the blocks are on the blocks that are close to, that are on the frontier, on the new frontier between Lebanon and the maritime borders between Lebanon and Israel. So does this agreement apply to the Israelis, and therefore the companies that will come and apply for or bid for that, should they be concerned about the agreement that Lebanon and Israel signed with the mediation of the Americans? So very interesting. So you gave me something to do over holidays now. During my Christmas break, look back to the deal and check it again if it applies to the Israelis.
Okay, thank you. Thank you.
Thank you very much, Laury, and also to complement to the discussion on the status, because it's a very interesting point, of course, when it comes to determining and qualifying also the status of this agreement. I remember, for instance, that in the preliminary objection decisions for the Kenya-Somalia case, there was the issue of determining, is this memorandum of understanding, even if rejected a treaty or not a treaty? And eventually the conclusion was that despite, this technicalities, this procedural element, that was a treaty because done by a person, concluded by a person with full powers, the Article 7 of the VCLT. So, but this is, of course, this is something that also will be interesting to discuss and to see in the future. I have, unfortunately, this is a very passionate and interesting discussion. Unfortunately, we are running out of time, so I will take the last question from Aniefa. Aniefa, please.
Okay, thank you. شكرا ومرحبا. بدي أسأل بس اللي فهمته من الموضوع إنه قدرة لبنان على الاستفادة من ثرواتها المائية مبنية على موافقة إسرائيل أو اتفاقها مع شركة توتال. هلا إذا إسرائيل عندها حسن النوايا راح يوصل لاتفاق، بس هي قادرة في أي وقت تعمل بلوك للبنان إنها تعمل استكشاف للغاز. الشيء الثاني اللي بدي أحكي إنه تسوية النزاعات حسب ما أنا فهمته بده يرجع للأمريكان. قديش اللبنانيين بيثقوا بالامريكان بالنسبه لهم وسيط نزيه، وليش ما اختاروش مثلا طريقه تسويه نزاعات اخرى زي تحكيم دولي او غيره؟ شكرا.
Okay, so I don't know. Do you want me to answer in English or in Arabic?
اللي بدك اياه مش مشكله.
Okay, طيب. Okay, I'll answer يمكن the first part and let Aref on the why we didn't go to the international court answer it himself. So for the first part, I think, as you said, the only mediator in this during the 10 years and the whole decade were the Americans. The Israelis, I guess, trust the Americans, and the Lebanese see value in negotiating with the Americans and the American mediator, even though there were claims that the mediator was or is an Israeli citizen. He served in the army, so he cannot be neutral. All of that had been raised in the Lebanese media, but at the end of the day, the Lebanese government decided to go through with the American with the U.S. mediator and with the U.S. administration mediation, as you want, regardless of who the person is, who the person negotiating is and mediating is. Definitely, as you correctly understood, there is a lot of veto power given to the Israelis. What the Lebanese is saying, but we got the veto as well, that we are not letting them go exploit in Block 72. Block 72 is on the Israeli side, and it is linked to Block 9. So most probably there is one, if there is a prospect, it crosses between 9 and 72. So that deal says that Lebanon has the upper hand in starting the exploration, and Israel cannot start exploring in Block 72. So they feel that this is Lebanon's veto power against Israelis. But when you go into the details, you see that like when Lebanon is going to start, there are a lot of veto power to the Israelis more than the Lebanese. But at the same time, we see that when Israel opened the licensing round, this last licensing round, they didn't open line, they didn't include Block 72 in it. Does that mean that they would that this is part of the deal? Yes. They're respecting it, yes, but this is the Yair government that has respected it. We don't know what the Netanyahu government will do. Netanyahu was very clear. He said, I will deal with this agreement the way I dealt with the Oslo agreement. So you go and understand what it means. And then I think one level, I only work with facts. What I know, if you want to project to another story, it's like I go back to Aphrodite, which is a field that was discovered in Cyprus in 2011, but a small part of it is in the Israeli EEZ. And until now, the Israelis and the Cypriots, and these are two countries that are amicable, they have amicable relations, two friendly countries, and they haven't reached an agreement. And therefore, Aphrodite, one of many reasons why it's not producing yet since 2011, it's because of the disagreement between Israel and Cyprus on this sharing mechanism. So you could see that it's happening between two friendly countries. So you can put it as one scenario that there could be a disagreement between Total and Israel on the financial agreement that could block the whole exploitation of that gas prospect if the gas is found. So we have to wait until end of 2023 to know if gas exists in Kana or not, and then we take it from there.
Thank you very much, Laury. I don't know, Aref, if you want to add something.
Yes, just to say that going back to the question whether this is a joint development agreement, as was suggested by or asked by Ademuni, I don't think it is, even though it talks about the exploration and exploitation, but it's not a joint development agreement to my sense. ومشان جاوب على الأخت حنيفة، حابب أقول إنه واضح إنه مثل ما ذكرت قبل الاتفاقية فيها غير توازن، لا توازن إذا بدك الموجبات على الطرفين. هيدا الشيء واضح بغض النظر عن طريقة الترسيم يلي تمت، يلي ما قدرت جاوب عليها بالمباشر، بس من ناحية تشغيل الحقوق المشتركة بس بهالموضوع الاتفاقية بتحكي عنه، بهالموضوع منلاقي انه في لا توازن بين الالتزامات من كل طرف. وفي موضوع سألتي أخت حنيفة عن موضوع الراعي واللجوء له بحال في أي يعني خلاف على تنفيذ الاتفاقية. ذكر وبتعرف إنه في تضعضع شوي من ناحية الأطراف، وطرف ما أكثر من غيره يمكن، فهالسبب يمكن هو وراء خلف الالتزام بالدولة يلي هي راعية للاتفاقية، يعني ما نكون عم نغمض عيوننا على الواقع يلي نحن فيه. شكرا لك.
Thank you very much, Aref. We reached the end. I see it. We are already 3 minutes, but I think it's really worth it. It was a very interesting discussion, and thank you very much to all of you who participated. Thank you very much to Laury and Aref for your contributions, and it was yes, it was very interesting to hear from you. And I would like also to thank, of course, our colleagues from Law for Palestine that made that possible, and the interpreters also for their fantastic job. Thank you very much, everyone. Of course, we hope to have you for another follow-up, maybe discussions on. Let's see also what will be the developments of this in this interesting field. And I wish all of you a very nice evening or afternoon.
Thank you very much.
Morning.
Have a nice evening. Bye.
Yeah,
Bye, everyone. Thank you.
Bye.
Bye.